In this class we want to talk about the sources of law in England. So we want to look at how law comes into existence in England and how it's developed over time. It's important to have an understanding of how law sources have impacted on the legal system, and especially with regard to our own areas in business, such as contract, employment and tort. So we need to know what are the sources of law and how have they come into existence. Now, the Constitution of the United Kingdom has evolved over hundreds of years. It's not a written constitution. There's no pieces of paper to say this is the constitution of the country. It's a non-written constitution. It's understood. The constitution is understood by the lawmakers and by the legal system. It's not a written document. So it has evolved, it's changed over time. Judges have changed it and lawmakers have changed it, have brought it up to date. It's constantly evolving given the new circumstances in which we live. Countries with a written constitution, in a sense, they are with that constitution. Even though the country is changing, the constitution is fixed. Admittedly, that gives certainty regarding the constitution, but it does also mean that the constitution can become out of date. Whereas in the United Kingdom, the constitution is constantly evolving. It's changing in accordance with changes in the law and changes in regards to the way we in society want the law to move. Now, as far as we're concerned, we need to look at several factors, but one of the most basic factors in terms of the sources of law is the issue of common law and statutory law. Now, let's look at common law first. This applies in England, and other countries have it as well, but many countries don't. We have a system of what's known as common law. It's also known as case law. Now, common law came into effect way back in history. Some people say back to the Norman conquest of 1066. Before a government structure had been created in the UK, law had been created through judges and the courts. So before there was any government, the law was created by judges and by the courts. That's how the law started. There was no government in history, or if there was a government, it was very weak, and it was not capable of making good law. So the law came through the courts. Those were the specialists. And the laws were based on cases brought to the courts. Common law, therefore, has its advantages because it's based on practical cases and real life situations. So the judges who were really making law, they were dealing with practical cases, disputes between people or criminal issues or whatever it was. They were dealing with these issues, and they were mostly private cases. But there could be a case of the local community wishing to have someone punished for breaking some law, some local law. So it was very similar to a criminal case. But what the courts were doing, were looking at the practicalities of the case. Who said what were the circumstances, and then trying to apply the logic, the reasoning behind their decision to other cases. So there was a consistency, and they were trying to apply what the ruling was in one case to another case. And this was the basis for common law. And it's still done that way today. and it works with statutory law, with law made by the government. So in England there are two types. There's common law and there's statute law. And the common law is exactly the same as it was back in history. The courts interpret the case, look at a particular case, interpret it, look at the facts in the case, look at all of the factors surrounding the case, and try to apply the principle of that case to other cases. And that's the basis of common law. There is something we need to be aware of here, and that's judicial precedent. In the legal system, it's important that courts' decisions are consistent. Similar cases brought to the courts must be treated in the same way. So there must be some sort of consistency. Common law was established by judges in the higher courts, which implied that these laws had a binding effect on lower courts. So, for example, in England today, the Supreme Court, if it looks at the facts of a case, or looks at all of the important issues associated with the case, and then makes a decision, gives a ruling on the case, then courts below the Supreme Court, looking at similar cases, must apply the same logic, the same reasoning, so there is consistency. And this is known as precedent. The lower courts must abide by the decisions sent from the higher courts. So whatever the higher court finds, the lower court must apply as well. Only the high courts, such as the Supreme Court, can change the laws regarding cases. So it's only the Supreme Court who can modify decisions. The lower courts must follow the Supreme Court. The judges decide the outcome of a case based on the similarity of material facts. They look at a particular case and try to find a similar case from the past. What was the ruling in the similar case, and then apply that ruling. The idea was created through what's known as the doctrine of stare decisis. Stand by what has been decided. So stare decisis means that you look at the existing court decisions and try to apply those decisions to any new cases coming through. So there is consistency. Needless to say, there's perhaps new interpretations in the light of changes in society. There might be modifications to the rulings, but these happen slowly and over time. And that means that common law is evolving slowly over time. There's another issue we need to deal with here, and this is what's known as the ratio decidendi and the operator dicta. In order to establish a precedent, the rule must acknowledge the ratio decidendi of the decision. This is the core decision, or the core reason for the decision. The ratio decidendi is the essential piece of law. You see, the facts of the case involved, say, Mr. A versus Mr. B, and there was an issue over something. This is, if you almost like, the narrative of the case. This is what the case was about in practical terms. But the ratio decidendi is the essential legal decision and why that decision was made. So it is the important part of the judge's summing up of the case. The courts may also decide to make a pronouncement which is called an operator dicta, which does not form part of the precedent, but may introduce persuasive authority for a similar case in the future. So the obiter dicta is discussing other parts of the case. It's not the essential ruling. The essential ruling is the ratio decidendi. That's what is important. That's what must be followed by all the courts under following on, and by the court itself in looking at similar cases in the future. So the ratio decidendi is most important. But the obiter dicta these are general comments made by the judge when finishing off the case, when summing up the case. The obiter dicta just simply brings other factors into account. They're not precedent, they're not binding on anyone, but certainly are factors which could be referred to if similar cases came up in the future. Now let's move to statutory law. Well, legislation created by Parliament came into effect through the Glorious Revolution in 1688. So it goes back a long time. Legislation is developed by government and passed through Parliament in the form of public acts, acts of Parliament. In England, the Parliament is made up from the House of Commons, which is the more powerful chamber, and the House of Lords. The House of Lords is not elected. The House of Commons is elected in elections, and because of the fact that it is elected, it is the more powerful institution. The government, who controls the House of Commons, brings forward legislation, brings forward laws, and they're voted upon in the House of Commons and also scrutinised in the House of Lords and passed in the House of Lords. And when they're passed in both places, they are then sent to the Queen to be ratified and to be put into law. They get the royal approval. Now, legislation passed in this way must be followed by everyone in the country. Laws passed by the House of Commons apply to all. Whereas common law may involve disputes between individuals. Statute law tends to apply to, well, applies to everybody. Law is covered by legislation developed by Parliament. Common law is secondary to Parliament or to parliamentary law. Common law is not as powerful as parliamentary law due to the principle of what's known as parliamentary sovereignty. The Parliament is the more powerful institution. That's the one that's elected by the people at general elections. So laws passed by Parliament are more important than common law, and Parliament can overrule common law. They can pass a law which removes aspects of common law if they so wished. So common law is easy to change. The judges change it. They interpret the law depending on the circumstances of the case, but also looking at the wider changes in society. So common law evolves over time. It's more flexible, whereas statute law is written down. It's fixed, and therefore has to be updated from time to time. Legislation is a lengthy process. In order to change legislation, a repeal is necessary. So if the government wanted to change some of its laws, it would have to repeal the laws that it made earlier and introduce a new law. So that's quite a lengthy process. It takes time and it takes effort, and it's costly. Whereas common law tends to evolve. Legislation can be passed in two methods. First of all, the primary legislation through Parliament, like we've been talking about, and secondary legislation, well, government ministers and delegated legislation. So it's possible for government ministers to bring through small pieces of legislation that influence their departments and get those through quite quickly. So let's sort of summarize here and talk about the difference between common law and statute law. Well, first of all, common law. It's based on precedents. Precedents means it's bound by higher courts. And new laws are created through the judges. Although judges will often say that they don't create law. But that's how the whole system of common law came into existence. They looked at custom and habit, and they looked at society and the way people lived, and they codified that as law. And that's where law started. If a law cannot settle a case, then the judge's decisions will give rise to a new law. And that's the basis on which common law sits. That's where it comes from. Now, statute law was law made by the government. And these laws are introduced to meet the needs of the public. They renew existing laws and resolve current issues. So two forms of law, common law and statute law. And these are the two important sources of law that we need to take into account. There are others, for example, the European law. And because England is a signatory to the treaties of Europe, it is bound by European law as well. And we haven't really talked about that, but that also is a source of law. And there are other sources of law in addition to this. For example, local authorities, local governments in England can ask to have laws passed as well. These are normally very specific laws dealing with local issues within their sphere of influence, but nonetheless. However, the point of this class is to look at the two major sources of law, which is common law and statute law, and to be able to contrast these. And that's what this class was doing. I suggest you go back over the class, stop it, make notes, wind it forward, wind it backwards, and make sure that you are clear on the differences between common law and statute law. But that concludes this class for now, so thank you for watching.